Hi, I hope everyone's doing well. Thank you so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the wonderful Jessica Murphy.
Thank you so much, Jessie, and I like you for more than just your first name. I always appreciate SunRay having me, and what I'm going to try to do in the next 15 or 20 minutes is hit you with a little bit of information about how you can actually get paid back liens, bonds, and contracts relative to Massachusetts projects. And hopefully you take at least one or two new things out of here. My last slide is a really good summary of what I'd like you to do next based on what we're talking about. So please hang on for that. If you have any questions as we go along, please go ahead and use the chat box to ask them. I'll answer all questions at the end. And please don't include your company name or any specific details in the questions, just so that we can talk more broadly about the issue that you're having rather than your specific customer or your specific company. All right, so our agenda, I apologize, the agenda is an old screen, so we're gonna skip that. Really what we're just doing here today is talking about how to get you paid faster. So starting with why getting paid faster matters. I'm sure, if you guys are here, if you're working with SunRay, you guys are probably the people at your company who are involved with your accounts receivables, checking how long it's been taking since you've been paid. So you guys do know time is money. Every day that your invoices are unpaid, you lose money due to inflation, debt interest, which means if you have to go out and take a loan to cover things because you're not getting your AR paid on time, and opportunity cost. What else could you be doing with that money that you don't have in your pocket? So this is what's referred to as the time value of money. And so it's the idea that $1 today is not worth the same as $1 a year from now. $1 a year from now has less value. So as a quick quiz, and unfortunately, you have no way to actually give me feedback on what you would pick, but I'll just jump right in. So which of these would you rather have? A $50,000 invoice that's paid in 10 days at a 2% discount, a $50,000 invoice paid in 120 to 240 days, a $62,000 judgment based on that $50,000 invoice plus 2 years of statutory interest. In Massachusetts, statutory interest is 12%. Or would you rather have a $78,000 judgment in 2 years based on that $50,000 invoice, but now you have contractual interest at 18%, so you're getting an extra 6% a year, plus you've got the ability to recover your attorney's fees, which is why that judgment value is 78 versus 62,000. So give a quick thought to what you would do in terms of which one of these would you rather have. I will tell you that any day, I think what makes the most sense here is A, getting an invoice paid in 10 days with a 2% discount. So you would be getting $49,000 if you selected option A, and you're getting $49,000 within 10 days. That's a really quick turnaround time, and most accounts receivables don't have time to register and start working on collections within that 10 days. So you've foregone the effort of having to work on getting paid. You've gotten money in, you're not having to take out loans against that. And that 2% discount probably makes sense. The next option is a $50,000 invoice that's paid in 120 to 240 days. That's typically a time frame in which we could get payment realistically if you've got a mechanic's lien. So that's a good time frame. If, again, we're assuming somebody's not paying you here. So if they're not going to pay you, the best I can get if we put a mechanic's lien down is probably payment within 120 to 240 days, assuming you've waited until the end of the lien time to go ahead and initiate that lien. So you're coming to me probably at day 80, or you're coming to SunRay at probably day 70 or 80, and then we're talking a little bit of time beyond that. The last two, although I'm an attorney, the idea of the last two is just to point out that, one, having a judgment is not as good as actually getting paid. You can get a judgment for more money because the court understands the time value of money and they apply interest. If you have no terms in your contract, the court in Massachusetts will give you that statutory interest, which is 12%. So if you had to go to court because somebody wasn't paying you, you're going to get a judgment. It'll take about 2 years. You'll get the invoice, assuming that you can prove all your damages, and you'll get 2 years of statutory interest. And that interest will continue to run until they pay it in full. But you're having to work under option C in collections. Option D is just a quick illustration to show you that your judgment can go from $62,000 to potentially $78,000 if you have the right terms in your contract. You're collecting on the same $50,000 invoice, but now you've got contractual interest, which is higher than the statutory rate. So you can put in 18%. In Massachusetts, you can go up to 22% without getting usurious. And you can also add your attorney's fees in, which you can't collect otherwise. So you can see there's some, which of these would you rather have? Yes, we'd love to have people paying on time. If you give a discount, you can probably get people to pay quicker. And overall, that's not a bad option because even if they don't pay you quicker, you haven't lost that because typically if you do net 2%, that discount goes away if they don't pay timely. With a mechanics lien, you'd be under B. Again, that's that time frame for if you're coming to SunRay to start filing a lien at about 70 or 80 days. Then in total, if you've got somebody who understands the mechanics lien and you've got everything you need to prove it, 120 to 240 days is kind of a realistic time frame to get paid for your mechanics lien, but you're getting paid that $50,000 invoice only. And then if you had to pursue it based on a contract, you're looking at your $62,000 to $78,000, and the higher amount being if you have a better contract. So just some illustrations as to how this really makes sense and is practical. So how do we get you paid faster? The first thing I would always recommend on construction projects is that you record a Massachusetts mechanics lien if you have the right to do so. You can record that as soon as the contract is executed. There are some contractors, some GCs if you're a subcontractor, and there's some owners, there's some owner reps who don't like it. There's some banks that don't like it. There are specific provisions in the mechanics lien law in Massachusetts designed to make sure that you can file this notice of contract early and have it sit out there, and it should not interfere with the project as it goes. There's often a lot of pushback, and sometimes a lot of the cases I get are where there's been a mechanics lien initiated, but then they've asked to have it taken off. I would strongly advise against taking off a mechanics lien because this is your absolute best way to work on getting paid. And the best way to do it is to record that notice of contract, that first document, as soon as possible. If you don't record it as soon as you execute the contract, and that's fine, most people don't, then the deadline for recording it is 90 days after the last date you've done any work under the same general contractor. So you should be looking to reach out to someone like SunRay, probably in your 70 days, 75 days around then. It does take time in order to get the mechanics lien notice of contract prepared and recorded. You have to make sure you have all the appropriate information. So getting the registry address and the book and page number for the piece of property is important because this is a recording at the Registry of Deeds. So you do have up until 90 days after the last work of anybody under the same general contractor has been doing work there. So if you are providing, for example, the concrete or you're doing the foundation, you have until the people doing the finished painting and providing the final trim and fixtures. You have within the whole project then 90 days beyond that in order to get your mechanics lien in Massachusetts initiated. Your next steps after initiating this, and this is what SunRay is going to help you with, is they're going to send out the appropriate notice to the owner. It's required if you are not the general contractor. And then they're going to take care of recording your statement of account, which has to happen within 120 days of last work on the project. So if you've waited until the end of your notice of contract period, then you've got essentially another 30 days to have your statement of account recorded with the Registry of Deeds. After that, if you still haven't been paid, it then transfers to an attorney to go ahead and file a lawsuit within 90 days of the date the statement of account was recorded. When we're talking about that estimate of getting paid on a mechanics lien within 120 to 240 days, that's because most timely filed mechanics liens will get attention upon the notice to the owner that a mechanics lien has been filed, and these are very powerful tools for getting you paid. So the next tool that we're talking about is collection on a payment bond. So it's the payment bond itself that benefits the contractors and subcontractors and sub-subs. It's the performance bond that benefit the owner. So when you do get a copy of a bond, take a look. Sometimes they'll say, yes, there's a bond, and they'll send it to you, but they may send you the wrong bond. So always make sure that you have one that's called a payment bond, which is what's going to benefit you. It bonds off and make sure that there is a surety in place to go ahead and pay you. In Massachusetts, if you're working on public construction projects, the law requires a bond be posted if there is a project worth $25,000 or more, and that's the prime contract amount. So you may have a subcontract that's $10,000, but there may still be a bond on a project because the total project is $25,000 or more. There can be bonds on private construction projects. That would be within the discretion of the owner. And sometimes for higher end projects, you may see that happen. Not always necessary, and certainly on private projects, they're not necessary. And sometimes you'll see them. You can always certainly ask about that. There may also be a bond, a mechanics lien blanket bond, which they would put on the property to ensure that there are no liens put on, but instead you would file against that bond rather than a mechanics lien. That is a special subtype of bond. And if you do find that there is a mechanics lien bond posted on the property, there's a whole bunch of different considerations. Happy to discuss in more details with anybody who comes into that situation in Massachusetts. The key on the key on payment bonds is you need to give notice that you have a claim against the bond within 65 days. So you don't want to wait until your invoice is 90 days old if you are a subcontractor or below, because in those scenarios, you'd be out of time. You must give notice within 65 days of your last work on the project. So that invoice essentially is less than 65 days old. So keeping track of the timing if you're a subcontractor is important. If you're the general contractor, you don't have the same notice requirements, and all you need to do is go ahead and just file suit within 1 year. Subcontractors also have to file suit within 1 year, but again, giving that notice within 65 days is an additional step if you are a subcontractor. Unlike mechanics liens, this notice requirement is within 65 days of your last work, not any other contractor's work on the project. So that is a distinction between mechanics liens and bonds. So this is the most important thing, is how do these things actually get you paid faster? So understanding this may help you convince somebody else at your company that these things are important and necessary to do. So here's your justification. There are additional parties who are going to be legally responsible for paying you, that you could enforce a judgment against if you needed to. You're not just relying upon your customer, who, if you're going down these roads, has not already paid you. So for Massachusetts mechanics liens, there is a huge incentive to pay the lien holder off once you initiate the lien. First, owners can be forced to pay twice if they ignore the mechanics lien. So if SunRay records your notice of contract for you, sends the notice to the owner, and then the owner continues to pay the general contractor, and you're a subcontractor, at that point, that does not protect the owner for the amount of your lien. It's not limited by those subsequent payments. You can, in fact, force the owner to pay you those same amounts they've already paid. Also, a judgment on a mechanics lien in Massachusetts results in an order to sell the property subject to the lien in order to pay off your lien. I've been practicing for 20 years in Massachusetts as a construction attorney. I have probably filed maybe, certainly hundreds of mechanics liens. I'm not quite sure if it's 1,000. And in all of those times, only 2 have gone to a judgment. And that's because owners, if they get legal advice, will understand the impact of these mechanics liens and understand that they are valid ways to get subcontractors and even general contractors, certainly vendors. It's a way to get you paid that is going to be enforceable so long as you meet the basic criteria of the lien. So they're very powerful for getting you paid. Bonding companies and sureties with respect to bonds are going to be responsible to pay a valid bond claim. So you don't have to worry about ability to pay. That's usually the reason you find yourself in these situations, is because your customer can't afford to pay you or has mismanaged their funds on a project. But if you now bring in a bonding company, which is a large surety, an insurance company, they're going to have the ability to pay you. Proving a valid bond claim is that you've done the work, it's for the project, and that you haven't been paid. Those are really what you need to prove in order to collect on a bond. So that's a very easy, relatively streamlined process. The bond company can assert any defenses that the owner or general contractor may have against you if you're a supplier or lower tier sub. However, what they're really looking at is the bonding company is going to get the information when they get the complaint. Usually it does not have to go to a judgment. Oftentimes they recognize what their liability would be under the bond. And as long as you can prove that you've provided the materials or done the work, it was good quality, it was within the scope of the contract, and that you haven't been paid, that you will in fact be paid. So again, these are fantastic ways to get you paid much quicker than if you were waiting around for your customer to pay or having to file suit. All right, how good contracts can get you paid faster. So having a good signed contract is the absolute foundation, pun intended, for a quick payment. First of all, because a signed contract is required for mechanics lien to be initiated in Massachusetts. Bonding companies, if you have a bond that you're trying to enforce, usually always ask for a copy of the contract. You can collect without a copy of the contract. However, it's more difficult, and you're not going to get that upfront prompt payment that you may by submitting documents after filing the case or after your claim. You may have to go through a little bit longer process and do more to prove your claim. So having a contract is great. Your contract can be specific for the project, which is best, or it can be your credit application, for example, when they start with a customer. Something that establishes that there is a relationship between the two parties, and here's what the terms are. This last point is important because even if you do not have Massachusetts mechanics lien rights, or if you do not have bond rights, because there is no bond, or perhaps you're untimely on your mechanics lien, or somebody has required you to release the mechanics lien, a good contract will get you paid more quickly and more completely for the losses you've sustained. What it should have to be a good, what I would consider a good contract, is that you really need to properly identify the customer's legal entity. You should know exactly who you're dealing with. So if you have to bring suit, you're bringing suit against the right entity. You also should know, the example I use here in Massachusetts is the classic coffee example. Dunkin' Donuts has some company-owned Dunkin' Donuts locations. It also has numerous franchises. If you are doing work for Dunkin' Donuts, please don't just have your guys in the office or women in the office write Dunkin' as your customer. You do need to know if you're working with Dunkin' Donuts corporate. You need to know if you're working with a franchisee, because you cannot tie corporate Dunkin' Donuts to an obligation that is done for a franchisee. Conversely, something like a Cumberland Farms, they own all of theirs. They do not franchise. So knowing those things, who your customer really is, what their legal foundation is, what type of entity they are, is key. Massachusetts has Secretary of State's website. Most states do. You can search there for the company. You can search by partial company name, and you can also search by some of the owners or officers or directors of the company to find that proper company name, or simply ask for it if you don't have it. Please include a contractual rate of interest and late fees if that's applicable. We can't have penalties in Massachusetts, so you can't require someone to pay 50% if they have a late payment, but you can impose some sort of late fees, which are typically about 5% of the late amount. Contractual interest, you start at 12% of statutory interest in Massachusetts, but you can go up to that usurious rate, which is 21%, So within there, a lot of people will choose 18% annually. It's 1.5% per month. In Massachusetts, you cannot recover legal fees unless it's stated in the contract. So again, that first example where you could potentially have a judgment for $62,000, or you could get potentially a $78,000 judgment by having the ability to recover your attorney's fees in the contract and to have 18% interest instead. So those are two things that really need to be in your upfront documents, the additional rate of interest and any late fees if you're going to apply them. Also legal fees, the recovery of costs of collection. The key here is it cannot be in the invoice that gets issued after your work. It has to be before in order to be part of an agreement between the parties. Last, you can get paid more quickly by having leverage. Leverage is often having the company owner sign a personal guarantee, which may be part of your credit app. So hopefully I've given you a little bit of information here that is new or just reinforces that you are doing the right thing. And maybe some information you can go back to your company to say, this is what I think we need to focus on or work on. So let's get practical. Here's what you can do with this information. I would like to see you going back and taking a look at your projects, figuring out if a Massachusetts mechanics lien is an option. It's an option when you have a signed contract. It's on a private property in Massachusetts, or it's a private project, that the work is ongoing within the last 90 days. And if that's applicable and you have projects that are applicable to a Massachusetts mechanics lien, please calendar the deadline. Put a note in there that says at 60 DSO, contact SunRay and start to figure out the next steps. Because you don't want to miss your mechanics lien deadlines. And it does take at least a couple of days for us to turn around a mechanics lien, get that recorded for you, and you want to make sure that they're being done timely. I also want you to take a look and see if you have projects that have bond rights. Is it a public project over $25,000? Have work been done in the last 65 days if you're the subcontractor? Get a copy of the payment bond. If you don't have that, be asking for it now. It's always easier to get payments if you haven't yet filed a claim or if you're not yet in litigation. So what I find, it's easy just to call and say, hey, I'm in the office. I noticed that we didn't have a copy of this bond, but it's a project that there should be a bond. Can you just send that over? Again, make sure you're getting the one that's called the payment bond. And then keep an eye that this would be a potential bond right project, and know what your deadlines are for making a demand if you're a subcontractor or for filing suit if you're a general contractor. And lastly, I want you to go back and review your contracts. Again, project-specific contracts or credit applications. Update your terms if necessary, if they don't have the right things, or just make sure that your contracts are being filled out appropriately. Schedule a review of your contracts every 2 years to make sure you're keeping up on terms, that things haven't changed, that you haven't merged companies and you're using some forms that have the old company name and some forms with the new company name. Get a check going at least every 2 years. And if you need to, use this as your reminder to request your customers sign a new credit application. Get updated information. I have frequently gone to court on credit applications that are 10 or more years old, and the court will look at you a little strange. It's great if there's been a history of working together over the last 10 years, but if not, and something goes, oh, it's an old customer, they've come back for a new project, please get an updated contract. I always like to say, you can say, there's a new sheriff in town, our new attorney said, we have to get these re-signed, and that's a great way to do it. But again, updating that information is fantastic. So hopefully this has given you a little bit of information as to why these things are so important and what they can do for you. It really does make a difference to get those mechanics liens recorded and enforced. If you have bond rights, to make sure that you're getting those and enforcing your bond rights. Those are the absolute best ways to get you paid. If you don't have those, or that's not an option for your company for other considerations, making sure that your contracts are going to help you get paid as quickly as you can, and by maybe applying a little bit of leverage, or just get you paid as fully as possible by making sure to get your attorney's fees back and to get you an appropriate level of interest and fees that covers how long the money's been outstanding. So without further ado, this has been open for questions. So Jesse, if you can let me know if we have any questions, I'm happy to take those.
Well, first of all, Jessica, thank you so much. I really do appreciate it. And yes, I like your name as well. Okay, so we do have a couple of questions that came through. This particular one, I think you actually already addressed, but I'll go ahead and pose it anyhow. How long is my lien effective?
So that's actually a great question. Once you initiate the recording of your mechanics lien, which is done by that notice of contract getting on record, it is good as long as the project is ongoing. You do have to take the next steps. So if that gets recorded and then up to the deadline of the notice of contract, then the next deadline is that statement of account deadline. So if the project ends, you've got 120 days to get that notice of statement of account recorded. And then from that date, you have exactly 90 days to file a complaint. But if the project is a 3-year project, then you get your notice of contract on, and that notice of contract is going to be good for 3 years up until the project ends, and then you need to keep going. Once you've filed suit, that lien, as long as it was properly perfected, it continues until the litigation is over.
Okay, all right, wonderful. Thank you so much for that clarification. Another question that came in, it says, can I amend my lien to increase the amount if I continue working on the project?
Yes, that's going to come up in 2 different places. Your notice of contract is a document that should identify the total value of your contract. It doesn't have to necessarily get into the nitty-gritty of how much you're currently due, because your notice of contract can be filed from day 1 of getting the contract, in which $0 is due. So the notice of contract is really just about saying, hey, I'm out here. This is how much my total contract is, so the owner knows what's going on. More likely, you're going to want to amend your statement of account, because the statement of account is that snapshot. When I file it at this time, this is how much is due. I do recommend amending your statement of account as you go along until you file the complaint, because you want it clear on the Registry of Deeds records how much is due. You would file an amended statement of account and just record that with the Registry of Deeds. Sometimes if you have a lot more work that's going on, or if it's a change order, you may consider whether you want to do it as a second mechanics lien, or if you just want to amend the first. So the short answer is yes, you can amend. I do strongly recommend doing it because it's a better way to encapsulate your damages up front. But you can also increase as you go along, because obviously you're continuing to do work.
Okay, all right, wonderful. Another question that came through, if I don't have a copy of the bond, but I have the bond number and surety information, can I still send the bond claim?
Yes, absolutely. The key on sending a bond claim is that obviously you need to identify the project correctly, and you need to identify and know where you are in the scale of things. I assume that you, in that scenario, are going to know who you're contracting with and where they are in the entire chain. So to know if you're a first tier subcontractor or a lower tier subcontractor. You can call the bonding company and request a copy of the bond. They don't have to send it to you, but they may. But otherwise, no, you don't have to have a copy of it. The key for having a copy is just to make sure that you're writing to the right people, that you've got the addresses down, the party names, etc., and you're making reference. But any statutory bond in Massachusetts, which again, those are the public projects for $25,000 or more, have the same statutory terms regarding notice within 65 days if you're a subcontractor, and subcontractors and generals need to file within 1 year. Those terms won't change. If you find that it is a private project that has a bond, again, that's the very unusual circumstance. I would suggest getting a copy of that bond, because there may be other terms in there that might affect your notice periods or your statute of limitations for when you can file. But generally speaking, public project, if you don't have a copy of the bond, but you have the bond number, absolutely, it's fine to just go ahead and make demand on that.
Okay, wonderful. And then I do believe this is the last question that's come in so far. On a private job that is bonded, can you file the lien and send the bond claim? So can you have both of them on there?
Technically, yes, as long as they don't have a mechanics lien bond. So that's that specialty type of bond where they will either go in and put a blanket lien on that says it's to cover the cost of the entire project, and you would file against the bond instead of the lien process. Otherwise, if it's a private project and there is a bond, that's just a payment bond, and there is a mechanics lien right because it's on property, you can do both. I am trying, you can do both. I'm trying to think if I had a preference. Nope. I am sending to as many people as possible, making the pool of people who can potentially be aware that you need to get paid and pay you as big as possible. So yes, if you do have the rights to do both, I would certainly think about doing both. The incremental cost of doing a mechanics lien is not that much. The timing are a little bit different, but I think take every opportunity you can to get paid, and those are two different pools of money. So the mechanics lien goes against the owner of the property, and the bond goes against the bonding company. So add more people. The deeper the pockets, the bigger the pockets, the better I like it. So great.
All right, wonderful. All right, well, thank you so much for explaining that and clarifying. If anyone does think of a question, please feel free to send us an email or give us a call. We'll be sure to answer any questions for you. All right, and then here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. I really do encourage you guys to do so. You'll learn a lot about each specific state. There's a lot of little states up there and right next to Massachusetts. Remember, each state is unique and different on their lien laws and documents and what they're requiring. So please check it out to protect yourself. All right, next slide, if you don't mind, please. All right, if you don't mind, give us a moment, a quick review on Google. We really do appreciate any feedback you're able to provide. It only takes maybe about a minute of your time. So if you're able to do that, I'd really appreciate it. Thank you very much. And then if you can go to the next slide for me. All right, and that is all we have for you guys today. Thank you so much to everyone who attended. We hope to see you at our next webinar. Jessica, again, you really are wonderful, so thank you so much. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone. Bye-bye. Have a great day.